principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients with their consumer law, employment law, and family law needs. Today's quick video is going to answer the question, what is a demand letter? In doing so, we'll first talk about the basic concept. Second, we'll talk more in depth about what is normally included in a demand letter. Third, we'll walk through an example. Fourth, we'll talk about some of the legal requirements and specific types of demand letters. And then last, we'll talk about the value of the approach of sending a demand letter yourself versus hiring an attorney to send that out for you. So let's talk first about the basic concept of a demand letter. This is not particularly complicated. The basic idea is you think somebody else did something bad to you, you tell them that, and then you demand that they do something. Maybe they pay you an amount of money, or they stop doing something, or else you'll file suit or take some other legal action against them. That's really it. However, a demand letter needs to be more than "you're bad, pay me money," or "pay or die," or some other short, brief sentence. A demand letter needs to lay out a detailed and persuasive argument about why the demand is valid and why they should pay you to avoid whatever legal consequences you have threatened. So let's talk a little more specifically about what should exist within a demand letter. So a demand letter should contain several portions. First, it should explain the facts that underlie whatever you believe this claim is against the other party. You should not explain every single detail, but enough to persuasively explain how it is, as a matter of the fact, you've been wronged by whoever the recipient is. You should also then lay out the specific legal claims, or at least the legal concepts that back up your demand and your argument that whatever legal process you intend to take is a valid one if they don't meet your demand. Third, you should explain the demand very clearly to them, what it is you want them to do or to stop doing. And then finally, you should explain what's going to happen if they don't meet your demand. And that's going to be filing suit. Maybe at that point you're going to hire an attorney to file suit, or follow some administrative process, depending upon what your particular claim is. So those are the basic elements of a typical demand letter. Let's walk through an example. Let's say that you bought a car from somebody, and this person promised you it's a great car, it'll run for years, it just got checked by a mechanic, and everything's perfect. You start driving down the street, you turn the corner, and it breaks down. Now you're out the money you paid for it, you don't have a car, you've got to pay for a rental until you can afford to buy another car. So you send a demand letter explaining the facts, explaining that there's maybe a breach of contract, a breach of warranty, maybe a deceptive trade practice claim, maybe some other stuff in there. And you say, hey, look, because you did this to me, because there are these legal claims out there, you owe me the money back on the car, plus maybe some other damages, the cost of the rental, for example. Pay me this money by X date. If you don't, I will file suit against you. And that's your demand letter. Let's kind of cut out any specifics about those claims and just sort of understand the basics of the way you would set up each of those sections within the demand letter. And of course, throughout, it's very easy when you write a demand letter for the first time, or maybe the first few times, to really want to write it from the standpoint of trying to terrify the other party that something truly awful is going to happen to them if they don't pay you some sum of money. That's usually not as effective of an approach as you might think. Lots of people, when they get demand letters, read it, crumple it up, and throw it in the trash and don't think twice about it. And that's because they know there's a pretty good chance that you're not going to follow through on what you said. Um, you may decide that it's not worth your time, or you may not follow through in the right process for it, whatever it is. A lot of people will just take their chances that nothing will happen. They don't really care. It's much better to present a persuasive approach that persuades them to want to negotiate with you or work with you to settle this claim, um, and to sort of open that door and let them work with you rather than trying to terrify them, because they're probably just not going to be that terrified. But that's basically what you need to do with a demand letter. It is worth understanding that in Texas, certain types of claims require specifics within a demand letter, and those specifics have to be present in order to preserve certain types of claims or to invoke certain rights under the law. These are common within consumer type claims, breach of contract, especially within Deceptive Trade Practices Act claims, um, claims against home contractors who have done work on your home. There's certain information and specifics that need to be in the demand letter in order to invoke um, particular rights under the law. There are some other laws or other types of claims where there are requirements for what needs to be in a pre-suit demand letter before you can follow through and file a suit on certain types of claims. But for the most part, consumer claims are typically where we find those. Um, Claims for attorney fees on any kind of contract or, again, consumer actions typically needs to be presented in that demand letter up front. Let them know that they're going to accrue attorney fees if they fail to meet the demand and you end up having to file a suit. Sometimes not including this information within the demand letter um, can have relatively minor consequences, but you may be precluded from, if should you have to go to trial on your claims, you may be precluded from being able to uh, receive an award of damages of a particular type or on a particular claim if you fail to present the information you need for the claims that you've alleged to the court. There's something else important to bring up here, and that's what you have to be careful not to do in a demand letter. Within Texas, there's something called an anti-SLAPP statute. Aside from having one of the best names for a statute in Texas, it's a really important and emerging area of law. What the anti-SLAPP statute says is that basically you can't use legal processes to try to shut people out of using their First Amendment rights. So that means if somebody is saying something about you online and you send them a demand letter threatening to sue them for saying bad things about you, they can invoke this anti-SLAPP statute and sue you first. And damages under the anti-SLAPP statute are pretty severe, even for sending something as minor as a demand letter directly to that person, just threatening legal action. And the idea there is those threats of legal action in a demand letter that are unassociated with any valid legal claim are only used for the purpose of trying to scare somebody out of their rights by oppressing them with the threat of basically using the state apparatus. And when you put all of that together, what it really amounts to is somebody is trying to force the state's hand through the court to impair somebody's First Amendment rights to free speech. This anti-SLAPP statute has been applied fairly broadly to claims that don't seem as obvious as maybe saying something bad about somebody online. So you really have to be careful when you're making those demand letters, and it invokes any kind of free expression or association or anything else that might come under the First Amendment, that you're really making claims and threatening legal action if there's a truly valid claim against that person. Otherwise, there's a very good chance you're going to see that anti-SLAPP statute appear in the way of a lawsuit against you preemptively. So definitely something to consider, especially if you're drafting a demand letter on your own. So that turns to our last subject, whether you should draft a demand letter on your own or if you should hire an attorney to send it for you. Some attorneys will send demand letters just as part of the process of representing you in a particular claim or lawsuit. Other times, if you have claims, oftentimes, especially with consumer law, you can hire an attorney to send that demand letter and just make the demand for you and not hire them specifically to do any representation beyond sending that letter and maybe doing a follow-up phone call for you. So there are some options out there versus doing it yourself. Of course, when you send that demand letter, you're taking the risk that you're not going to invoke that anti-SLAPP statute, that you are going to hit all the legal requirements to preserve your claims, that you have the skill set to be able to carefully value your claim and present a persuasive argument why the recipient should pay the demand versus letting you decide to do whatever it is you're threatening to do. But beyond that, there are also some concerns that when you send a demand letter on your own, that you're boxing in your own arguments by presenting certain facts or by presenting the facts in a particular light or making certain arguments about the legal claims, because there's a chance that those demand letters may become part of the evidence in your case. And if you've said one thing in the demand letter, then and perhaps you want to position your argument in a different way down the road, or your attorney wants to position the argument in a stronger way, that initial demand letter may box out some of those better arguments for you. As well, of course, if you're not including all of the claims that need to go into the demand letter or hitting all of those legal requirements, again, you might find yourself unable to pursue the claims and get the kind of damages you deserve for something that somebody else legitimately did that caused harm to you. It's easy to think this is just a letter, it's just a shot in the dark to try to get them to pay you an amount of money or to even just open up negotiations to try to get the claim resolved. But that letter can have truly serious consequences, particularly in the anti-SLAPP lawsuits, but even just for your own claim. So really think about, is it worth your time to try to figure out how to draft a particular demand letter, or does it make more sense to hire somebody who is trained in researching your claims and to drafting these persuasive demand letters, and what's going to give you the best result? And so those are things to consider. What is right in one situation may not be right in others. You may be just fine writing a demand letter on your own, but if you choose to go down that path, you're always going to take that risk that you're wrong, and you're going to have to live with the consequences of whatever process you choose to follow for yourself. So those are the basics of a demand letter. As always, I hope this information was helpful. If you're looking for more information about those consumer claims or about the mechanics of litigation, there are some other videos on my channel that discuss these issues. There's also a ton of information on my blog that discusses these, and I would invite you to go take a look at that on my website. But I think that's a good stopping point for now. Again, I hope this video was useful, and I want to thank you for taking the time to watch or listen as is more appropriate, and I'll see you next video.